would have the benefit of the valuable knowledge we give out every time we are here. Now, the question I'm posing this afternoon is very simple. How to make and win an appeal. Now, you put in an application and it's refused. The main reason they give sometimes quite flimsy. And I've had occasion where some of the lawyers, including the principal, gets quite upset that this doesn't make sense. Why would they refuse this on this flimsy excuse? Then the question is, if I want to appeal against such a decision and it goes to the tribunal, how do I even present my evidence to say that the Home Office or whoever the caseworker was wrong? The question is going to be answered today, and it's so critical and important that you stay with us. Uncle Ben, how do I, in the ordinary man's term, make and win an appeal?
Yeah, Kweku, I think it's a very, very important question. Most people would have experienced very successful cases, would not have come into contact with a tribunal or the court system, and therefore may not be aware of the difficulties that our people go through when it comes to appeals. So an appeal is a statutory right that is specifically defined in law under the 2002 Nationality, Immigration and Asylum Act. Section 82 clearly defines what an appeal is, an immigration appeal, and also other legislation like the EUSS and the withdrawal agreement have also got some parts of right to appeal for EU and their EU nationals and their non-EU family members. The appeal itself, it's not difficult. So if the Home Office makes an adverse decision, you may have a right of appeal or a right for administrative review. Both are statutory provisions, but the details of each is different. Okay. The administrative review is usually done by the same caseworker at the Home Office to say that he may have missed some evidence or he hasn't considered your case carefully. But a right of appeal enables you to put in grounds to challenge the decision on legal grounds, okay, and also on factual basis, and then have the opportunity to go to court and speak to the judge about your evidence. Okay. So it's very crucial. And I say it's crucial because there has been changes since 2015 where some restrictions have been put in place preventing immigrants or applicants from exercising a right of appeal, which they usually would have had prior to 2015. So for example, if you're a student and your student application is refused, you don't have a right of appeal, but you have a right of administrative review. Okay. The difference again is that with administrative review, there's no opportunity to make a representation, an oral representation.
It has to be a written something.
It will be a written representation on evidence that they may have missed or did not consider. So first of all, your right of appeal lies to the first tier tribunal, okay, which goes to an independent person. These are either solicitors or barristers who have some experience in immigration cases. Once you've received your decision, there are timelines. So there's a time limit in which to make those appeals. Okay. For example, if your decision is made in the UK and you're residing in the UK, you have 14 days from the date the decision was sent, not when you received it, but when it was sent.
Oh, okay. Again, so in this case, if there's a delay in post, it would affect you? Of
course, but you will need to explain because the rules also gives you the opportunity to make an application for extension of time. Okay. So if the decision is dated, let's say the 30th of January, okay, and you received it on the 18th of February, of course, it's more than 14 days since it was sent, but that is the date you received it. So you could put in an application for extension of time and explain. There's some confusion. Some people believe it's a date of receipt. No, it's a date that the decision was sent. Okay. The 14 days, that's when we count it from. If you're outside the UK, it's 28 days from the date of decision, not date of when it was sent, so date of decision. Okay. So these are timelines that you need to be aware of. Now, it didn't say the appeal after 14 days. It says the court must receive your appeal within 14 days of when it was sent. You need to settle your grounds of appeal. Bear in mind that the statute itself defines what grounds you can put in your appeal on your appeal paper. You can either do the appeal online or you can do it by paper. Either way, you still need to state the reasons for you still need to state the reasons why you're challenging it and attach the reasons for refusal. Now, crucially, once the appeal has been lodged, you will be given an opportunity to come to court. You will get a decision to come to court and then prosecute your case. The burden of proof is on the appellant. So the person who settles the appeal has a burden to prove that the Home Office is wrong. Now, although I say that the burden of proof is on the appellant, in certain cases, the burden of proof is on the Secretary of State for the Home Department. Two cases comes to mind. There's a case called Afago, and those cases, which is where the Home Office has made an allegation of a sham marriage or marriage of convenience. If the Secretary of State makes an allegation of a sham marriage or a marriage of convenience, the initial burden of proof is not on the appellant. It's on the Home Office to show that the marriage is a sham marriage. Again, where an allegation is made that you forged a document or you have provided evidence which is of a criminal nature, again, the burden will lie on the Secretary of State to prove by evidence why that, to prove by law why that evidence it's, of course, misleading or false. Otherwise, the burden on the appellant is a usual civil burden, which is a lower burden of a reasonable probability. So it's not like the criminal burden where it is beyond reasonable doubt. Once you've been given the opportunity to come to court, you also have the opportunity to put in a statement, a witness statement. I'm sure most Ghanaians
well, obviously,
that, with the Supreme Court case and have come to understand several parts.
You swear an affidavit on it to say that this is true and that is what you are sticking to. Okay,
in the UK, in our civil procedures, we do what we call a statement of truth. The effect is almost the same. So if you're lying, of course, the court can make adverse findings against your credibility, and that could affect the outcome of your case. So your statement, now this is where I put a lot of emphasis on winning your case. So your statement will form part of your evidence, because evidence is defined as either oral or written or documentary. So your statement is part of your evidence. Your statement does two things. Your statement has to be credible and it has to be persuasive. So if I say credible, then credible in the sense that whatever you're saying must be the truth. It may be, you may put a gloss on it, you may shine it up, you may put special emphasis on aspects of your case, but it must be the absolute truth. And that's why I said it must be credible. So it must be believable. And again, it must be persuasive. So for example, if I say something is persuasive, it means that the ordinary man in the street will come to your side of the case rather than the Secretary of State's side. These two principles are very, very important to win appeal cases. How do you give a credible statement and how do you give a persuasive statement? Your duty is to respond to mainly an allegation by the Secretary of State. So if I take a typical EA case where the allegation is that you haven't established a familiar relationship or a family relationship with a sponsor because your birth certificate was recently obtained, and the knowledge of the Secretary of State is that if somebody is born in Ghana, the person will be given a birth certificate in any event within 12 months or 2 years. Your birth certificate is about 25 years late, so that means that it's not credible. How do you respond to that? So to respond to that is not to say, well, it's credible. It's credible. He's my father or he's my son.
What happened that you got it 25 years late?
You have to explain. You can give an explanation. But also, if you have any other thing that can corroborate the evidence. For example, if you've got a birth certificate, you're 25 years old, the birth certificate is 2 years old. But you've got a baptismal certificate, which is about 24 years old. You've got your first terminal report when you went to primary school.
Okay.
You've got maybe a letter from the hospital, which is maybe about 18 years old. And you've got your weighing card and other things, which clearly shows that the details that you've given is corroborated. Bear in mind that those evidence that I've referred to may not answer whether you're related to the person
or not.
But it may confirm your name and your date of birth. Okay. So you're taking some of the doubts out of the case. You can also give a biological or scientific evidence, which is a DNA. The DNA is not compulsory, but again, is a tool available to you to challenge the Secretary of State's assertions. All they've given is an assertion. The other part that I want people to concentrate on is that it's not every time that you can produce a new evidence. Within the appeal right, under Section 84 and Section 85, there are restrictions of what evidence can be led. So if the decision was made in the UK and the appellant is in the UK, you can lead evidence, any evidence, up to the day of the hearing. So, for example, if they said that, well, this is not right, you're not married, but subsequently you're now married, at the date of the hearing, you can provide a marriage evidence. If it's an outside case, Section 85(4) of the 2002 Act says that you can only provide evidence which speaks to the situation at the date of the decision, not the hearing. Okay. So there are two different scenarios. And that is why I always put emphasis on the fact that once your application is refused, it's always smart to instruct a lawyer, and not any lawyer, but a lawyer
who understands the situation.
Who is very, very competent. Because there are strategies in winning the appeal. But the bottom line is that the evidence is what you have. It's the way you present the evidence, which I say must be credible and persuasive, that sometimes sways the judge to your side of the case. Bear in mind that you also have the chance to bring in documents. What you are not allowed to do is to raise a new matter. The definition of a new matter is anything that has not previously been considered by the Secretary of State. Okay. That is the definition of a new matter.
Okay.
The reason is that under Section 84, you cannot raise a new matter which has not been considered by the Secretary of State or which the Secretary of State has not consented to. Okay. The court will not have jurisdiction to look at the new matter. What is a new matter? Example, if I say that this is my partner, okay, and then subsequently we say we are not married, but on the date of the hearing, we managed to get a marriage certificate from Ghana to say we are now married. Okay. That is not a new matter. That is a further development from this is my partner.
Kind of confirming the assertion you've made on your...
Well, initially you were not married, but you said you were partners. And now that you're married, it's new evidence, but not a new matter. What would be a new matter is that you're relying on your husband to make an application. Right. The application is refused. And then suddenly you say, we've now got a child, so I'm now relying on my child. Right. Now, that is a new matter, and that should go to the Secretary of State, because if it doesn't go to the Secretary of State within the grounds of appeal or as a Section 120 notice, then on the date of the hearing, the PO or the presenting officer can object to that evidence or prevent the judge from listening to that particular evidence because the Secretary of State has not had a chance to look at the evidence. However, the rule says that where they can make a decision within the time of the hearing, then the court will hold on for them to make that decision, and then the case will proceed. Again, if somebody is applied for asylum, and then once the asylum case is gone to court, maybe 2 days before they're now married to an EU national, you cannot put that evidence before the court, because the court is not allowed to listen to that evidence because that's a new matter. But if somebody is applied for asylum, and then 2 days before the hearing, the person gets a police report from Ghana to confirm that, yes, what this person is saying is true, that is not a new matter. That is new evidence, and the court or the judge is allowed to listen to it and to look at the evidence.
So if I understand you clearly, when you lodge an appeal, you must provide new evidence, not necessarily a new matter. If it is a new matter, then it has to go to the Secretary of State to look at that before it could be admitted as part of your appeal.
Absolutely. So when you look at the appeal forms, it says a grounds of appeal. It's a new matter. So the appeal forms itself gives you the chance to raise a new matter. Okay. And it gives the Secretary of State an opportunity to look at the new matter. However, if at the date of hearing, the Secretary of State has not had the opportunity to look at the new matter, the court cannot listen to the new matter. But new matter is different from new evidence. Because if you provide new evidence to the court and the decision was made in UK and the appellant has an in-country right of appeal, you can provide evidence to explain a situation that existed at the time of the decision up to the date of the decision, up to the date of the hearing. But with entry clearance, you can only provide evidence up until the date of decision. So any new evidence or new explanation after the decision, of course, if it's explaining the situation that existed at the time of the decision, you can't produce it, else you're not allowed to provide it. The other part that I want people to focus on is that in addition to settling your grounds of appeal, your statement, you also have the chance to put in a skeleton argument. So a skeleton argument will be, as the name depicts, it's, you know, a brief explanation of your legal and factual position. So it would usually deal with the issues to be decided by the court. It would deal with a brief facts of the case. It will also deal with the sections of the law that you seek to rely on. And again, the case law that you seek to rely on. So usually maybe maximum 2 pages of skeleton argument, because you will have the opportunity in court to explain to the judge in full exactly what precedents that you're relying on. Now, please be aware that your case stands as your evidence in chief. So by all means, put all your eggs in that one basket. This is the only time that I would advise you to put your egg in one basket.
I was actually going to say that could be dangerous.
Cool.
But pair your strategy.
Yes.
Is the best thing to do.
Of course it is. Because remember that sometimes your counsel may not call you to give evidence. So you may just adopt the evidence and then you're not going to be led in evidence. So your evidence in chief, your statement will serve as your evidence in chief. It also takes away the stress on you because, listen, court environment is very stressful. And usually this will be people who've never had any encounter with a judge or a lawyer in a very adversarial situation. So it's very stressful. You know, you can't be downbeat, and clearly because your demeanor is part of the assessment of your case. If you're fumbling and you're eyeing and you're missing your evidence and you're forgetting your dates, it becomes a problem. That is why I'm saying that put all your evidence in the statement. The statement will talk about you. So your opening will say, I, Bernard Owusu of 123 London Road, make this statement in support of my appeal. This is an appeal, this is a statement challenging the Secretary of State decision dated so and so. I'm a British citizen and I'm married to this person. On this date, we made this application. The application was refused because the Secretary of State said, blah, blah, blah. We're not married, the customary marriage, I wasn't there, and our children were born somewhere, and I haven't been to Ghana for all these years. So then you explain, the reason why I haven't been to Ghana for all these years is that blah, blah, blah. But you will also be aware that we've had 2 children in the interim. I send money to them regularly. I speak to my wife regularly. This are the evidence, the WhatsApp messages, the emails, the text messages, the money transfers. And also remember that my auntie here goes to Ghana regularly. So when she's going, this is what I send to them. We write love letters. Valentine's Day, she actually sent me flowers.